This video covers the topic of federalism, which is an important part of section 1 of the A-level syllabus. Federalism is right at the heart of the constitutional settlement of 1787, which created the United States of America. There are different stages in the history of federalism, i.e. the relationship between states and the central government over the course of American history. And federalism, compared to the UK, is not covered in a great detail in this video. But remember that in the UK, it's a unitary country to compare with federal. Everything really is quite centralised in Westminster, but it's gone a bit further towards federalism over the last few decades in both directions, both in the devolution of power to Scotland, Northern Ireland and Wales, but especially Scotland, and in its the definition of federalism is where political power is divided between a national government, the centre, also known as the federal government, or Washington DC when we're talking about America, and local governments, the states in the United States, California, New York and so forth, each having their own area of substantive jurisdiction, that is jurisdiction that is meaningful. States' rights is a huge debate even now, and we'll see it come up quite a lot in this topic. Those who believe in states' rights defend the powers and independence and the rights of individual states and don't like to see the federal government having too much power. Their argument stems from a belief that that is historically true to the great American dream, that individual states choosing democratically their own path is a very American thing, and the federal government should be very limited in how it takes power from the localities, and that's very undemocratic, and it's the sign of the elites pushing around a little guy. But in every important way, in feel and in philosophical and ideological tenet, people who believe that the government shouldn't be there and the individual should do what they want, libertarians and many in the Tea Party and the Republican right, see as a kind of proxy war for the battle for individual rights, the battle for individual states to have more power and the federal government have less power. And there's the argument about states' rights is very much at the heart of the culture wars in America, this very deep partisan battle between those sort of globalist, modern, activist, northern Democrat identifying people in America, and those more likely in contrast to be Trump voters, particularly from southern states. And there's probably misspelled here, but unresolved Civil War issues, or if you'd like to put it even more bluntly, this clash between city and country, between north and south, between rich and poor, between sort of citizens of nowhere and those very rooted in their state, has been bubbling along for all of American history. The Civil War was a great spillover of that, and it continues to be part of the debate. Now, the Constitution deals with the relationship and the relative powers of the central government and the states in three ways, really. The first way is the enumerated powers. Those are the ones that are literally numbered or bullet points in the Constitution that state in black and white which are powers for the states and which are powers for the central government. Next are the concurrent powers, which are a little bit difficult to understand because the Constitution gives these powers both to the individual states and to the central government, which of course can cause some confusion and make interpretation by the Supreme Court very, very difficult. And finally, there are implied powers, and these are powers that the federal government has seized on a loose reading of the Constitution, sometimes backed up by activist and loose constructionist Supreme Courts. The enumerated powers of Congress, and therefore the federal government, include several very uncontroversial ones, such as to support armies, coin money, establish post offices. But here we can see in the enumerated powers the two clauses, the Commerce Clause and the Elastic Clause, which give rise to the federal government being able to claim lots of implied powers. Article 6, Section 2 of the Constitution. And it says that all federal laws and treaties made under the authority of the government are superior to state laws, and that the Supreme Court and the US Constitution is superior to the constitutions of the individual states and the individual states' Supreme Courts. If you couple this with the power that the Supreme Court has seized and the areas that it now views as justiciable, in other words, things that it can make the judgment on because they can be argued in a courtroom, you can see how this clause has given much power to central government. You can see here in more detail the implied powers that come from Article 1, Section 8. Provide for the common defence and general welfare of the United States has been used to justify plenty of power by federal government. But more than anything else, the Commerce Clause has been used by the federal government to claim that it has the power over quite a lot of domestic policy, because quite a lot of domestic policy affects the economy, and if it's affecting the economy, it's affecting commerce among the several states. An example is Gonzalez versus Reich, 2005, which established that even if states made marijuana legal, the federal government could still arrest and maintain the illegality of marijuana. Another great example is South Dakota versus Dole.
South Dakota v. Dole, 1987, is a really useful example to use when you want to talk about how the federal government can withhold funds from a state in order to force it to do what it wants. South Dakota had a lower drinking age than other states of 18 or 19, but the federal government wanted every state to have a drinking age of 21. Now this is an area that really does fit into states' rights, so what the federal government did was they tied funding for highways to the Drinking Age Act, and South Dakota forced to have a drinking age of 21, otherwise they wouldn't have got any money for their roads. They took the government to the Supreme Court, which ruled that amazingly this was okay under the spending clause. That's the one in Article 1, Section 8 that says the federal government can maintain general welfare, and that was how they justified their decision to allow the federal government to wield this.
And anything not justified by the Commerce Clause or the Supremacy Clause or the General Welfare Clause can be argued to be justified in terms of federal power through the Elastic Clause, whereby the federal government can argue that it's necessary and proper to pass a law or to take an executive action in order that one of its enumerated powers can be carried out properly. This, alongside the Commerce Clause, was used by Obama to justify the compulsory nature of the individual mandate in Obamacare, and in the very important case, National Federation of Independent Businesses versus Sebelius, 2012, Supreme Court actually said, no, Obamacare can't be justified with these. But anyway, it can be justified as a tax. So a little bit of a fudge from the Supreme Court there, but just an example, a recent, very important example of why and how the Supreme Court has to judge the nature of federal versus state power. Concurrent powers are simultaneously exercised at state level and at federal level. The best example of concurrent powers is the election clause in Article 1, Section 4 of the Constitution, which says the times, places and manner of holding elections will be prescribed in each state by the legislature of that state. So far so clear, enumerated for the states, but the Congress may at any time by law make or alter such regulations, which is very confusing. The key test case on this clause is Arizona versus the Intertribal Council of Arizona of 2013, which revolved around Arizona's unique voter registration requirements, including the necessity of providing documentary proof of citizenship. In the 7-2 decision, the Supreme Court held that Arizona's registration requirements were unlawful because they are preempted by federal voting laws. In other words, it held that the Voter Registration Act of 1965, which said that you couldn't have tricky and difficult arrangements for people to register to vote, because those tricky and difficult voter registration arrangements were used by racist states to prevent non-white people from voting, that couldn't be law, and the federal government had the right under this clause to make that decision. So what have we seen with federalism in the Constitution? The Constitution is set up and established by Hamilton and Madison to have limited government. This was more important to them than there being power at the centre or power in the states. They wanted there to be very little power exercised by the government because they wanted people generally to be free, and they feared the tyranny of government. That said, they wanted the country to be united, they wanted the nation to be strong, so they erred on the side of quite a lot of federal power, which they thought by and large would be more responsible than states. And that federalist urge has given many governments in Washington DC the excuse and opportunity to be quite activist, and activist Supreme Courts have supported that using the Commerce Clause, the Elastic Clause, and so forth. But right at the start of this crucial debate, which still is important in America today, anti-federalists got a fight back in the Bill of Rights, Amendments 1 to 10, especially the 10th Amendment, which states that the powers not delegated to the United States by the Constitution, nor prohibited by the states, are reserved to the states respectively, or to the people. But US v. Darby 1941 ruled that this was a mere truism, by which the Supreme Court meant that obviously the things that are not written here are written there, and didn't have much meaning, much to the irritation of people who wanted to use it to fight for the rights of states. In summary then, the enumerated powers are the powers that are written down in the Constitution and state clearly whether the power belongs to the individual state government or to the federal government. Concurrent powers are powers that are written down in the Constitution, but state not very clearly that the powers belong to both the state government and to the federal government. The implied powers are the powers that the federal government has grabbed on the basis of vague wording in the Constitution, which they take to mean that it implies that they have powers to do this, that, or the other, such as the Elastic Clause. And the 10th Amendment states clearly that things which are not enumerated or mentioned in the Constitution automatically default to being reserved to the states or the people, but the 10th Amendment hasn't been successfully used very much by states' rights activists to assert their authority because of the Supreme Court decision, US v. Darby. The textbook splits the history of the United States and the nature of its federalism into dual federalism, cooperative federalism, and new federalism up to about the end of the 20th century, and then just talk specifically about the Bush and Obama presidencies and the state of federalism there. Most textbooks and studies agree with the first two, but they're a little bit, new federalism is a little bit of a simplification, and in fact the last 30-40 years are a little bit more complicated than that would imply. The period between the foundation of the United States and 1920 or so is known as a period of dual federalism because they focused on very clear enumerated rights and privileges, and the state government, the federal government, the local governments all did their own thing separate to each other without clashing. It's sometimes described as a layer cake. The states had pretty strong rights to do most of the domestic policy. Federal government was very limited and didn't really interfere with people's lives and the economy so much, other than printing money, going to war, making peace. But then the economy changed. The Wall Street crash happened in 1929, and Franklin Delano Roosevelt was elected to office and took the Keynesian view that it was the job of the central government to manage the economy. So he passed things like the National Recovery Administration Act and the Agricultural Adjustment Act of 1936. And these were ruled unconstitutional at first by the Supreme Court because it was such a huge increase in federal power, an increase in federal power that Roosevelt felt was needed in order to prosecute his New Deal, and that was a big spending and public works program to cure the mass unemployment and huge economic problems. A constitutional crisis, therefore, between what the Supreme Court said and what Roosevelt felt he needed to do, and one that was resolved by Roosevelt's court packing